Well, the Liberty Fighters Network claims that government's lockdown regulations are legally over. They're opposing an application for leave to appeal by Cooperative Governance and Traditional Affairs Minister, that's Dr. Nkosazana Dlamini-Zuma. Earlier on this month, the High Court in Pretoria had ruled that aspects of the lockdown are unconstitutional and invalid. However, the ruling was suspended for 14 days to allow the minister to review, amend and republish those regulations. The LFN is arguing that government has failed to amend the regulations by the 23rd of June's deadline. All right, for more on this, we're joined via Skype now by my colleague, that's ENCA reporter Barry Bateman. Barry, good morning to you. Let's touch on this. Of course, today is D-Day, where we understand that the Cooperative minister will be appealing that ruling by Judge Davis. What exactly are in her application, in her report?
Yeah, good morning, Tomela. Well, there are four main grounds which Minister Nkosazana Dlamini-Zuma is attacking the ruling that was issued those 2 weeks ago, as you've stated. The first being that it did not raise, or the applicants rather, did not raise a valid constitutional attack on the regulations. The minister says they raised an attack under the Bill of Rights on, and this is how they quoted, unidentified regulations on undisclosed grounds for an unknown reasons. Now, they say this is a problem because it states that the applicants state that they extensively violated the Bill of Rights. That's how they had argued this, which they said they would argue at the hearings. They actually said that. They didn't put it in their papers. They said they had argued the various grounds when it comes to the hearing. And this made it defective, according to the minister, because it made it impossible for her to know what case to meet. The second aspect was that the High Court strayed beyond the pleadings. Now, the application was an attack limited to the state of disaster regulations up into and including level 4. It was not aimed at level 3. So the minister is saying it wasn't aimed at level 3, which at the time that this was actually heard in court hadn't even been promulgated at that time. So this meant that the minister was never called to defend level 3 regulations and indeed never had an opportunity to do so. The other aspect was the third ground is that there was a wholesale declaration of invalidity. They say this was unjustified. The court held that there was a limited number of provisions under level 3 that were invalid. And if it didn't stand, it wasn't justified then if you found just a few of these regulations invalid that you would strike down the entire regulations. And then that last point 4, the High Court's order was unduly vague. The minister arguing that the order instructs the minister to, quote, review, amend and republish the regulations. Now, they argue that this is unduly vague because it does not tell the minister what is required from her to comply with the order. So that, in a nutshell, are the four grounds upon which that the minister is relying on to argue that another court could reasonably come to a different opinion based on the application.
Now, with that being said, have we seen the opposing papers? Do we know where they stand with this appeal?
I have had sight of them. They're going ahead, and the thrust of the argument from the organisation is that there was nothing vague in their papers. They made it quite clear that they were attacking all of the regulations. It was said as much in their particular papers. In the founding affidavit in particular, they say that the constitutionality and the validity of all the provisions and regulations was under attack. So on that basis, this claim from the minister that she didn't know which aspects of the case or which evidence to produce because it was all over the show, they say that it simply doesn't hold any water. And that appears to be, from what I've gathered, it's very short responding papers. I must say, it's just 14 pages. That is the thrust of the opposition coming from the organisation.
So they still insist that the order needs to be enforced?
That's right, and this is on the basis that, and they criticize the minister, saying that in this 14-day period, the minister didn't choose this opportunity to consult with all the relevant stakeholders and to amend the laws and to come up and republish new. She rather chose to file this application for leave to appeal, which they say was ill-advised. And it's on this basis, of course, we're not going past that deadline of 14 days as was set down by the court. Therefore, the court order must come into an effect and essentially makes all regulations or all lockdown regulations null and void. That is the argument.
Barry Bateman, that's where we'll leave it. Thank you so much for this update. ENCA reporter Barry Bateman on, of course, that court case between LFN and Cooperative Minister Nkosazana Dlamini-Zuma.